start by saying how proud I am of my very good professional colleague, Nabenyo. This is the very first act for a lawyer to give prominence to Article 43. And I know, as has been stated by the good men and women who have spoken before me, my good friend, Senator and Speaker at one time, Emeritus Ekwe Thuro, was present when we were making the Constitution. My good friend, Dr. Ekuru Aukot, and I'm happy that one of the delegates at the Bomas of Kenya, delegate number 321, is present with us. And many of us sometimes forget why it is that we agitated for a new constitutional dispensation. The older people here will remember that when we regained our independence, the constitution that we inherited, if you may, was actually enacted by the British Parliament as Act number 1968 of 1963. It was not meant for our societies, not the Turkana, not the Kamba, not the Jaluos, not the Samburus. This was a constitution to cater for a post-colonial country and to be in the image of a post-colonial country. You must never forget that when the British were leaving, they were giving constitutions to their former colonies. So that when you look at the character of the Kenyan constitution, the Ugandan constitution, the Tanganyikan constitution, the Malawian constitution, the Zambian constitution, the Ghanaian constitution, the Nigerian constitution, and I dare say to a certain extent even the Indian constitution. There are common elements in those constitutions. And you must never forget that the British did yet another thing. They said that we would now belong to a body called the Commonwealth of Independent Nations, which is a post-colonial institution. And they told us that ours is a common law system. Common law. Those of you who are lawyers here, and somebody I think is the chairman of the professionals who spoke about it, among others, and I think Nabenyo also talked about it, we are proud when we are saying Lord Danning, Lord Atkin, and until a few years ago, the common man in Kenya was described as the man in the Clapham omnibus. Mtu wa kawaida wa Kenya alikuwa analinganishwa na muabiri wa basi kule Uingereza. It is Madame CJ who said that that cannot be true. The common man must be the man in the Pangani bus. But he said so because he was an Indian who grew up in Pangani in Nairobi. Had he grown up here in Turkana, he would have said the man in the goat market in Lokichar. So that is what you are asking us to talk about this morning. So our justice system is a foreign justice system. If you look at land, what is the law that governs land in this country? For a long time, we had the Indian Transfer of Property Act as the law that governed land in Kenya. We had the Government Lands Act, the Registered Titles Act. Then we had what was called the Registered Land Act, was actually borrowed from Australia, the Torrens system of registration. That is how alien our land laws were. Marriage was defined as the union of one man and one woman to the exclusion of all others. Yet you and me know that in an African setting, marriage is the union of one man and one woman to the inclusion of all others. The Muslims were a little bit more deliberate, because many did sex notwithstanding whether Sunni or Shia, except the Ismailis, they allowed up to 4. So there was an offense. Still is, if you don't marry under the proper legal regime, called bigamy. Umeoa kanisani, ukaapa ya kwamba utakuwa ni mme wa mke mmoja. Alafu baada ya hapo unanyemelea. Unaoa mke mwingine kwa mila na desturi za Kiturkana au za Kisamburu. Ukipatikana utakiona kilichomtoa kanga manyoya. Our law in that regard was alien. Criminal law. Amesimulia. Na amesimulia ndugu MCA yale ambayo yanaitwa makosa ya jinai. Pia yalitokana na mila na desturi za wazungu. Hivyo ndivyo tulivyoridhishwa sheria hizi. And that is what became our law. Whether you are Turkana or Samburu or Luo, Mkamba or Mdigo, that is our law. We started dismembering our constitution. Tukaanza kubadilisha. Wale ambao ni wazee, mzee hapa atakumbuka, miaka ya 64 tukaanza kubomoa. Sasa kulikuwa na majimbo, tukaanza kubomoa. Akina Masinde Muliro, akina Ronald Ngala, wale ambao ni wazee watakumbuka, kulikuwa na wimbo ambao ilikuwa naimba, hata Muliro ni kigeugeu, alikula asali ya masharia. Hapo ni 1964. Masinde Muliro wakavuka, wakatoka Kadu wakaja Kanu. Tukabadilisha sheria. Sheria ikabadilika mpaka mwaka 1969. Tukabadilisha katiba, tukatoa Act number 5 of 1969. Ndio katiba ambayo ilikuwa sasa ilimwezesha rais kuwa kama mfalme. Na kufikia mwaka wa 82 katika uongozi wa Daniel Moi ikawa ni chama kimoja, na mtakumbuka. Na mtakumbuka uchaguzi wa 88 ya Mlolongo. Moi kwa njia yake alikuwa anahoji hivi. Anasema, na vitu hivi tulivyo virithi vinatufaa. Unampa mtu kura kuweka kwenye kisanduku, na ukimuuliza huyo mtu, je, ulimpigia ndugu Ekwe? Anakuambia, mimi sikumpigia ndugu Ekwe. Ukikutana naye anampigia Ekuru, wewe ndio nilikupigia. Tukawa ni kura ni ya uongo tu. akasema mbona tusiwe na kura ya uwazi? Na mnakumbuka katika mlolongo line ambayo ilikuwa refu ndio ilikuwa inashindwa. Sasa na pia tukashangaa, na hii ni kitu kipi? Sasa tukawa tunasema tubadilishe